Dear learners, we shall be starting with the discussion on the various kinds of companies that can be formed under the company law. In particular, we would be discussing their concepts, features, structure, along with the provisions governing them under the law, especially Company Law and the Companies Act 2013 that contains the legal framework for various kinds of companies. Since the number of companies that we shall be dealing with under this topic are vast in number, so we shall be discussing this topic over multiple lectures. So in this lecture, we shall be taking the first part of the kinds of companies. In a way, this is a continuation and an extension of our discussion on the various kinds of business organizations. So in the other lectures, we have already had a detailed discussion on some of the general features, characteristics, and nature of a company. So in extension of that, we will be looking into the various kinds of companies under this topic, which are also kinds of business organizations which a founder of a business or an entrepreneur or a promoter of a company, as it is called as, they can form. So beginning with, as you would know that during the course of discussion on this topic, there are numerous kinds of companies. Now the question is that how do we explain the various kinds of companies, or how do we classify them? Many of such companies are both relatable as well as differentiable from the others based on some concepts, principles, and features. So for the sake of simplicity and clarity of understanding of our learners, I have classified the various kinds of companies under 9 broad heads. Now these heads are: number 1, the mode of incorporation. Here essentially we would be discussing what are the various ways in which the companies can come into existence. Then we have on the basis of liability, whether companies have limited liability or unlimited liability. We will be discussing it under this head. Then on the basis of ownership, whether they are privately owned or they are governmentally owned, will be taken up under this head of ownership. Then fourthly, on the basis of nationality, whether it is a Indian company or a foreign company, what distinguishes the two kinds of companies would be taken up under nationality. Then on the basis of control, we have holding company, subsidiary company. One is a company which controls other companies, and the other is a company which is controlled by other company. So whether an entity is being controlled or it controls, whether it is dominant or subservient, would be taken up under this head of control. Then access to capital, we are specifically looking at whether they have access to the stock market, or investors or potential shareholders, whether the company is listed on the stock market or not. Then on the basis of number of members, there are various kinds of companies: public, private, and one-person company. What are their various features, how they are differentiable, would be taken up under this head. Then on the basis of size, we have a small company and companies other than small companies. And lastly, we have a residuary clause of other companies. So under this head, I have put here those companies which do not fall under any of the preceding 8 heads. So this other companies are those companies which are not fitting under any of the classification as above. So in this lecture, which is part 1, I shall be taking up 2 kinds of classifications. And what companies come under those classifications? The first is the mode of incorporation, and second is liability. So we will be taking up these two classifications in detail. Beginning with the mode of incorporation, as I said, the mode of incorporation signifies what are the various ways in which the company gets incorporated, or it is born, or it comes into existence. So under this head we have firstly what we call as a chartered company, then we have a statutory company, and thirdly we have a registered or incorporated company. Now we shall be dealing with each of these three companies in further detail. So a chartered company, as the name suggests, they are those companies which are formed through a royal charter which is granted by the crown on a monarch. They originally came into existence in the 16th century when royal charters were granted to trading companies, especially for the purposes of overseas trading, exploration, and colonization. A very well-known example of chartered company is East India Company. This company, founded in the year 1600, was granted a royal charter by Queen Elizabeth I, giving it a monopoly status on trade with East Indies, a very vast geographical region which included India. Chartered companies generally enjoyed monopoly status in either a particular geographical area or a particular trading item. These companies derived their powers from the royal charter which constituted them. These companies originated during the colonial rule, and so, with the demise of colonization with time, they have virtually become extinct. So, chartered companies no longer exist in India, and the Indian company law does not contemplate creating chartered companies. So, our discussion here on chartered companies is only of certain conceptual and academic relevance, because legally speaking, no more chartered companies can be formed under the Companies Act 2013. The next kind of a company that we'll be discussing is a statutory company. Now, as the name suggests, these companies are formed by a statute. Now, a statute can be an act of parliament or an act of state legislature. Otherwise, these companies are also popularly known by the name of statutory corporations or public corporations. Their existence, powers, objectives, and limitations are defined by a specific legislative law. Whereas the law for a statutory company is the legislature which creates them, it is unlike a chartered company whose law was the royal charter which created it. Now, statutory companies are generally established to undertake functions which are considered to be in public interest, such as managing specific sectors of the economy like finance, banking, insurance, etc. Since these companies have an underlined public interest, they balance the need to earn profitability with being socially responsible. So, profit only is not the only objective of these companies, but they have a larger social economic goal underpinning their formation and functioning. Now, these companies are generally financed either fully or partially by the government, depends upon whether it is formed by an act of parliament, in that case the central government, if formed by an act of state legislature, by the state government. Though they may enjoy a degree of operational autonomy, however, their operations are subject to strict government oversight and control. They are governed by the Act which establishes them and not by the Companies Act. So while certain provisions of the Companies Act may influence their formation and functioning, but the majority and predominantly the law which regulates the formation, functioning of these companies is the statute which brings them into existence. A very well-known example of a statutory company is the Life Insurance Corporation of India, which was established through the parliamentary legislation Life Insurance Corporation Act 1956. Then lastly, under this classification, we have a registered or an incorporated company. Now, these kind of companies are those which are formed under the Companies Act 2013 or the predecessor law of Companies Act 2013, that is the Companies Act 1956. Section 7 of the Companies Act 2013 prescribes the procedure for incorporation of a company. These companies have documents known as the Memorandum of Association and Articles of Association. Now, these two documents prescribe the functioning of these companies, wherein their powers, objectives, and limitations are derived from these documents. So just like in a statutory company, its powers, limitations, and objects are provided in the statute which forms them. For a registered or incorporated company, it is the Memorandum of Association and the Articles of Association. Most of the companies which are in existence today, they are registered or incorporated companies. So the word company that we generally use in common parlance for various kinds of companies of which we are consumers, they are generally registered or incorporated companies. Now we would be analyzing the difference between statutory and registered company in some detail. Beginning with their formation. So as we know, a statutory company is formed through the legislation which creates them. So by legislation we mean there is a independent special legislation which has been enacted in order to create such a company. Example is Life Insurance Corporation. Whereas for a registered company, there is no need for a new or a special legislation, as they only have to be registered under the existing company law. Then on the aspect of governance, the statutory company, the legislation which creates it is also the law according to which a statutory company has to be governed. Whereas for a registered company, there are two very important documents known as the Memorandum of Association and Articles of Associations, which in short are referred to as the company constitution. So just in the same way as there is an importance of a constitution in a democratic nation such as ours, similarly the memorandum and the articles perform the function of a constitution in a registered company. The purpose of a statutory company is, mainly speaking, a public purpose for a larger social or economic goal, whereas the prime objective of a registered company is profit, except if a registered company is for charitable objects or a guarantee company. Now, what is a company with charitable objects or guarantee company? We will be taking it up in later lectures on this topic. The ownership of a statutory company is usually by the government, maybe a state government or a central government, depending upon which legislation has established them. So if it is the Parliament of India, then the ownership is likely to vest in central government. But if it is established through a state legislature, then the ownership is likely to be vested in state government. Whereas registered company, they are privately owned. And by privately owned, we mean by non-government entities, except the case of a government company, which shall be discussing in a later lecture. Now, we generally have many number of registered companies which are very common as compared to statutory companies which are very less in number. So we have more instances of registered companies than statutory companies. So this is all we have insofar as the classification of companies on the basis of mode of incorporation. Next, we move on to the second kind of classification, which is on the basis of liability. Here we have firstly a company limited by shares, secondly a company limited by guarantee, thirdly a company limited by guarantee with share capital, which is a conjugation of the first two kind of companies, and lastly we have an unlimited company or unlimited liability company. Now we shall be discussing in some detail each of these four companies which fall under the head of liability. So firstly, a company limited by shares. This kind of a company is defined under Section 2, Subclause 22 of the Companies Act 2013. According to this provision, a company limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. So as you would acknowledge, this is a very technical definition, but to simplify it for the benefit of our learners, it means the liability of members is restricted to the value of their shareholding. The expression company limited by shares can be misleading, as the word limited denotes that it is the liability of the members of the company which is limited and not of the company itself. So in some of our previous lectures, we have already discussed in great detail while discussing the features of a company as to what is limited liability, what is meant by it, and a connected theory to it, that is theory of owner shielding. So limited liability essentially is for the benefit of the shareholders. So if the company falls into any financial trouble or distress and creditors have any unmet claim against the business of the company, then the personal assets of the shareholders remain protected from the business creditors of the company. So for more discussion on what is limited liability, refer to our discussion on limited liability which we had while discussing company as a kind of a business organization. Next we have a company limited by guarantee. This kind of a company is defined under Section 2, Subclause 21 of the Companies Act 2013. According to this provision, a company limited by guarantee means a company having the liability of its members limited by the memorandum to the such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. So essentially speaking, this kind of a company has guarantors who seem to protect it against any financial trouble or distress because of which a company may be wound up. So as you know, the definition that is provided under Section 2 Subclause 21 is a complex definition with a lot of legalese, but to simplify it for the benefit of our learners, it means the liability of members is restricted to the amount of guarantee undertaken by them to contribute to the company if it is wound up or faces any financial trouble. The expression company limited by guarantee can be misleading, as the word limited denotes that it is the liability of the members of the company which is limited and not of the company itself. A company limited by guarantee is a company which is unlike a company limited by shares in the sense that it does not have any share capital or shareholders. Instead, it has members who act as guarantors. So while in a company limited by shares, you call the owner of shares as shareholders, but in a company limited by guarantee, those who contribute capital to the company, they are known as guarantors. Now these guarantors or members, they agree to pay an amount in the event that the company faces financial difficulties such as winding up. Next, we have a company limited by guarantee with share capital. Now this kind of a company is not defined under the definition clause of the Companies Act, but the reference of this kind of a company is made under section 285 clause 3 subclause E of the Companies Act 2013. A company limited by guarantee with share capital is kind of a hybrid company or a cross or a combination of the two companies discussed above, that is a company limited by shares and a company limited by guarantee. Then we have unlimited company. This kind of a company is defined under section 2 subclause 92 of the Companies Act 2013. According to this provision, unlimited company means a company not having any limit on the liability of its members. To put it simply, unlimited liability means that the members of a company are personally responsible for all debts and obligations which are incurred by the company, irrespective of whether the company has sufficient assets to cover them. So this is very unlike a company limited by shares in which the shareholders have limited liability. In unlimited liability company, the shareholders are exposed to greater risks over their personal belongings and assets from the business creditors of a company, in the sense that if the debts of the creditors of the company cannot be met from the company's finances or company's assets, then the business creditors of the company can lay a claim on the personal assets of the shareholders. So this kind of a company suits more the creditors rather than the shareholders. So it is kind of hostile to the shareholders and it is more friendly to the creditors. The expression unlimited company can be misleading, as the word unlimited denotes that it is the liability of the members of the company which is unlimited and not of the company itself. So now we will be discussing each of the four kind of companies in more detail. Firstly, a company limited by shares. So its members are known as shareholders who contribute capital to the company. Now this type of a company has a capital which is a sum total of contribution of shareholders, and hence it is called share capital. So the contribution of individual shareholders is put up together and collectively, cumulatively, it is known as a share capital. Now the shareholders in a company limited by shares are entitled to profits which are distributed to them as dividends. Along with the name of the company, the word limited or the word private limited is added. The word limited is used in case the company limited by shares is a public company. On the other hand, the words private limited are used in the case of a company limited by shares is a private company. What is a public company, what is a private company shall be discussed in a later lecture. A company limited by shares is generally used by businesses that aim making of profits and distributing them to shareholders as dividends. So company limited by shares is the most popular and widely used company amongst the various classification of companies which are there. So the incidence of formation of a company limited by shares is the most. Next we have a company limited by guarantee. Now in a company limited by guarantee, the members are known as guarantors. Now this kind of a company does not have shareholders and it does not have a share capital. Instead, it has members who act as guarantors. Now these guarantors agree to pay an amount to the company in the event that the company faces financial difficulties such as winding up. The capital of the company is raised through membership subscriptions, fees or borrowings and not through shares. While there are no legal restrictions on distribution of profits, it is common for the guarantee companies to restrict profit distribution to its members in the form of dividends. Such profits, if any, are usually reinvested to further the company's non-profit activities. Now, a company limited by guarantee, they are usually set up by non-profit organizations which require corporate status. Therefore, an organization that would typically set up a company limited by guarantee is a company which is a religious body or charitable body or social welfare body or any other body with such kind of objects. Generally, companies with charitable objects which are dealt with under Section 8 of the Companies Act 2013 are companies limited by guarantee. Although it is not mandatory for a Section 8 company to be a company limited by guarantee. However, if a company limited by guarantee distributes profits to its members, it is most likely to lose its non-profit status and become ineligible for charitable status under Section 8. I shall be dealing with a company with charitable objects in a later lecture. Next, after discussing the two kinds of companies, we will be taking up their differences. So, on the aspect of liability, a company limited by shares, as we know, has limited liability, where the liability of shareholders is limited to the value of their shares. In the same way, in a company limited by guarantee, the liability of the guarantors is limited to the guarantee amount that is undertaken by them. Then the raising of the capital in a company limited by shares is through share subscription. Of a company limited by guarantee is through donation, fees or borrowings. The main purpose of a company limited by shares is profit, whereas of a company limited by guarantee is non-profit. The profit is distributed to shareholders in a company limited by shares, but not in a company limited by guarantee, in which case it is reinvested in the company's charitable or social welfare activities. So the use of a company limited by shares is generally for profits or for businesses that aim profit generation, and for a company limited by guarantee for charitable or social welfare activities. Now we shall be taking up the third kind of a company under the classification of liability, which is company limited by guarantee with share capital. Now this kind of a company is a rather rare exception. While most companies limited by guarantee do not have a share capital, some non-profit organizations or charities, they may choose to incorporate with both the features. Here a company is primarily structured as a company limited by guarantee with a share capital. Its members act as guarantors and shareholders, so both obligations combined into one, as this kind of a company is a combination of a company limited by shares and a company limited by guarantee. Now, this structure allows a company to raise capital through shares while retaining its non-profit focus. The profits, they are reinvested into the charitable objects of the company rather than being distributed to its members. So while it does have a share capital, the emphasis does remain on social welfare activities of the company. The total liability of a member in such kind of a company is the sum of the guarantee amount and the unpaid value of the shares. So, for example, if a member guarantees to contribute 1000 in case of winding up and has unpaid shares worth rupees 500, their total liability would be rupees 1500. So, the liability is counted or assessed on the basis of guarantee amount and share capital amount. Then we have an unlimited company. As already explained, unlimited liability means that the members of a company are personally responsible for all debts and obligations that are incurred by the company, irrespective of whether the company has sufficient assets to cover them. If a company with unlimited liability incurs debts or liabilities, the members' personal assets, like their home, savings, or other property, it can be seized to satisfy those debts or liabilities. Now, this kind of a company is unfriendly to the shareholders as they face heightened personal risk. Such companies therefore face challenges in raising capital and expanding operations through share capital. On the other hand, they are more friendly to the creditors, and they are regarded more creditor friendly, as the creditors are more likely to extend credit to companies with unlimited liability. The reason is that creditors can access the personal assets of the members to cover their debts, if any, which remain unmet. Therefore, the creditors have a greater assurance of repayment of debts. The rationale of an unlimited liability company is a very pertinent question and a natural one, that when a company can be incorporated with the benefit of limited liability, what is the rationale for registering a company with unlimited liability? Now, situations in which an unlimited company will be preferred include: number one, for example, if a company is predominantly dependent on credit for its capital requirements, then unlimited liability accords greater assurance and confidence to the creditors of the company. Second, the creditors may insist on incorporation of a company as unlimited liability company as a condition for advancing credit. So, when the company is being formed and the promoters of a company are looking for capital from external sources like creditors, so at the time when the company is about to be incorporated or in the process of incorporation, the creditors may insist that we desire that you register a company as unlimited liability so that we have greater assurance. The third reason why an unlimited liability company may exist is if a company has sufficient capital and does not need to rely on external creditors for its capital requirements, then the risk of unlimited liability may be acceptable. The nature of business of unlimited liability company is generally low risk and probability of insolvency is less. Now, whether a company registers itself as limited liability or unlimited liability is a matter of policy or choice of the founders or promoters of the company. Then moving on to the difference between limited liability companies and unlimited liability companies, just to briefly summarize them. the shareholder liability is limited, whereas in case of an unlimited liability company, it is unlimited and beyond their investment in the company. The personal assets of the shareholders remain protected in a limited liability company, whereas they are exposed to heightened risk in case of unlimited liability companies. So for limited liability companies, creditors are more at risk and they feel more protected in case of an unlimited liability company. Whereas for the shareholders, it is the other way around. They feel more protected in a limited liability company than in an unlimited liability company where they have more risk. So a limited liability company as a kind of a business organization, it is more suited for those kind of promoters or entrepreneurs who want to raise capital from external sources by shareholding or subscription of shares or by giving membership or ownership to investors such as shareholders. Whereas unlimited liability company is more suited to those kind of businesses and promoters and entrepreneurs who want to raise capital from external sources, but not through issue of shares, but through capital which is to be borrowed from the creditors. With this, we would now briefly summarize the contents of this lecture. So, beginning with, we had discussed the classification of companies and had an overview of the 9 heads of classification. From those 9 heads of classification, we have undertaken a discussion on the first 2 heads, that is the mode of incorporation, in which we discussed the 3 kinds of companies differentiated by the factors through which they are brought into existence: chartered company, statutory company, and registered or incorporated company. Then on the basis of liability, we have discussed 4 kinds of companies, that is company limited by shares, company limited by guarantee, company limited by guarantee with share capital, and unlimited company. Wherever necessary, for the sake of clarity of understanding of the learners, we have also discussed the differences between and amongst the companies that we have discussed. With this, we shall be ending our lecture 1 on the kinds of companies. Thank you very much.